What happens when a judge gets demob happy? The answer can be seen in the intervention by the imminently departing President of the Supreme Court, Lord Neuberger, in the debate over the role of the European Court of Justice, better known as the ECJ, once Britain leaves the EU. The government will doubtless be less than delighted at another dissenting voice in the Brexit process. Judge calls for clarity on status of ECJ rulings in UK after Brexit. Read more. The ECJ has long been a bugbear for Brexiteers, and some might say with good reason. The court has expanded its jurisdiction dramatically over time, meaning that an ever-increasing number of issues fall within its remit. It's never been a good look for judges in Luxembourg to be able to strike down laws passed in Westminster, and the judgments coming from the ECJ are an odd mix, encompassing elements both of our own common law system and the civil law scene across the continent. Theresa May set out a negotiating red line in her party conference speech last year that Britain would not up sticks from the EU only to remain under the ECJ's jurisdiction. That's not going to happen, she pronounced confidently. The trouble is that, as with much of Brexit, the headline is far simpler than the specifics. As Neuberger's intervention shows, it may be impossible to shake off the reach of the ECJ, however much the government tries. This is not so much about a lack of political will, but a matter of legal reality. The government can hardly be said to have backtracked the draft bill on withdrawing from the EU says that the ECJ's rulings will no longer be supreme for any law passed after exit day. So far, so clear. As for previous decisions made by the European Court, this too is spelled out. Where the ECJ has decided something, and the British courts have therefore been required to apply that decision, the end result will remain binding here. Facebook, Twitter, Pinterest. No wonder Neuberger feels that the position is invidious.